Thank you, sir. Okay, sir. At the outset, I thank Dr. Chandramoli, sir, for introducing me to the audience and for giving me an opportunity to speak on human rights of workers. After the lunch, it is really a challenging task. I can understand. I do my best to draw your attention over the topic. Without going in detail about the concept of human rights, different classes of human rights, or generation of human rights, like first generation, second generation, and third generation of human rights, and without going in detail about the historical background of human rights at the national level and the international level, I will focus on human rights of workers as it was assigned by the coordinator, Dr. Chandramoli, sir. Workers' rights are debatable issues. Today, due to COVID-19, millions of workers have lost their job or the employment. Their economic situation is really pathetic. Employers are reluctant to pay wages and comply with the labor laws during COVID-19. Even if you approach the court of law, it's very difficult to get the relief because the court will take up important cases for hearing. Issues of workers are not considered as important matters by the court of law. Coming to the topic, human rights of the workers. As I said, it is a debatable issue. There has been a lot of debate, a lot of the discussion or discourse about the nature of rights of workers. Whether rights of workers are human rights or statutory rights or fundamental rights or constitutional rights. Some scholars argue that rights of workers are not human rights. And they try to justify their own contention, arguing that rights of workers would not cover, or human rights would not cover the rights of the workers. Whereas, the contrary to this, the other scholars argue that workers' rights are human rights because they are fundamental for the exercise of other rights. However, it is very difficult to determine the nature of rights of workers. As I said, it is very difficult. You may argue that workers' rights are human rights. At the same time, you can argue against this proposition that the workers' rights are no longer human rights. But if you look at the international developments, in particular, human rights, the development, you feel that workers' rights are human rights. And if you look at the Constitution of India, in particular, the Part 4 of the Constitution of India, you do find some provisions which exclusively deal with the workers' rights. So here, so far as workers' rights are concerned, everyone has the right to work. We as a human being, we have a right to work. This is the foundation for the exercise of or enjoyment of other rights. if you say that workers' rights or right to work is not a fundamental right or the human right, then it will be easiest way to deprive your right to life and liberty. Right to work is protected by the law, international law and domestic or the national law. Therefore, workers' rights are the human rights. So what are the human rights of the workers? Workers' rights comprise varieties of rights, from the decent work to equal opportunity and protection against discrimination. Workers have the right to just and favorable conditions of work, fair wages, equal pay for equal work, equal remuneration for the work of equal values, minimum wages, decent living for themselves and their families, safe and healthy conditions of work, right to reasonable work hours, adequate rest, leisure time, periodic paid, the holidays. Workers have the right to associate with one another, bargain collectively for improving working conditions and living standards. They have a right to form and join a trade union of their choice. Trade unions have the right to form national and international organizations. Workers have a right to strike as long as it is consistent with the domestic laws. Collective rights of workers cannot be subject to any restriction other than those prescribed by law on the ground of a social interest, public order, and for the protection of rights and freedom of others. No doubt, the workers have these rights. Now the question is, what is the nature of these rights? What is the nature of these rights? What clauses of what category of these rights are? What kinds of rights are these? Whether these rights are human rights, or statutory rights, or constitutional rights, or fundamental rights. Workers' rights are human rights, provided that they are mentioned in the human rights conventions and treaties. In particular, Universal Declaration of Human Rights of 1948, International Convention on Economic, Social, and Cultural Rights of 1966. If you look at Article 23 and 24 of UDHR, Article 6 to 9 of ICESCR, they recognize the workers' rights as human rights. So question whether the workers' rights are human rights or not, the answer is very clear. If you read Article 23 and 24 of UDHR, Article 6 to 9 of International Covenant on Economic, Social, and Cultural Rights, they made it very clear that the workers' rights are human rights. Article 23 of UDHR, Article 6 of ICESCR recognize that right of everyone to choose freely and accept work. So under Article 23 and 24 of the UDHR, it is our right to choose freely and accept work. Nobody can compel us. Nobody can force us to accept the work. It is our choice, our freedom to choose the work which is suitable to us, and right to enjoy just and favorable conditions of work. If the condition of work is not ensured, it is our right to deny to work in an inhuman condition of work. It is our right to demand the minimum wages, equal remuneration for the work of equal value, a decent living, a safe and healthy working conditions, equal opportunity in the employment, subject to competence and seniority, and right to form and join the trade union of our choice. It is our freedom of association. The right to strike is a human right recognized by the UDHR. Article 7 of ICE-SCR recognizes or provides that everyone has the right to rest and leisure. So it is our right to rest and they demand the leisure time, including a reasonable limitation of work, how long we can work, in what conditions we can work. It is our freedom. It is our right to demand periodic holidays with wages and remuneration for public holidays. Article 9 of ICE-SCR recognizes right to social security. So according to Article 23 and 24 of UDHR, Article 6 to 9 of the International Covenant on Social, Cultural and Economic Rights, the workers' rights are human rights. When the workers are human rights, it is the obligation of the states to respect, protect and fulfill the right to work. When we say that it is our human right, then there is the duty or the obligation on the part of the state to respect, protect and fulfill our right to work. It's not enough to respect. It is the duty of the states to protect and fulfill these obligations. How can the states respect the human rights of the workers? So 3 factors are to be taken into consideration. Availability. It is the obligation of the states to ensure the availability of employment opportunities and help the people to identify and find the work. Availability of employment is a must. So without providing employment opportunities, without helping us to find the suitable job, we cannot get a suitable job. Therefore, it is the responsibility of the state to ensure the availability of employment opportunities and help the people to find the work. And the second factor is accessibility. States must ensure that everyone has the right to seek, obtain and impart information about employment opportunities. Without accessibilities or without the accessibilities, it is very difficult for us to seek, obtain and impart information about employment opportunities. So it is the responsibility of the state to ensure that everyone has a right to seek, obtain, impart information about employment opportunities. And the third factor is accessibilities. It is not enough if we have availability of employment opportunities or accessibility of information. What is equally important is acceptability and the quality of work. It involves right to choose and accept work freely, just and human conditions of work, safe working conditions, and right to form the trade unions. So when we say that workers' rights are human rights, there is corresponding duty on the part of the state. So in a jurisprudence, we argue that where there is a right, there is a corresponding duty. Without corresponding duty, there is no right. Similarly, when right to work is our right, there is corresponding duty on the part of the state to provide an opportunity to work. Workers' rights will be statutory rights if they are protected by statutes. The workers' rights will be the statutory rights if they are protected by the states. Right to equal remuneration, right to equal pay for equal work, right to continue in employment, right to remedy for unlawful termination, right to compensation for injuries, right to maternity benefit, medical benefits are protected by the statutes like Workman Compensation Act, Industrial Disputes Act, Employees Provident Fund Act, Maternity Benefit Act, Factories Act, Equal Pay Act, Payment of a Gratuity Act, and etc. The human rights of workers will be the statutory rights if they are protected by statutes. In the absence of statutes, then workers' rights will not be a statutory rights. Without a statute, it is not possible for giving effect to the human rights of the workers. When you have the statutes, when the statutes are enacted by the parliaments, then only human rights are enforceable, or else it will be mere rhetoric in words. When the workers' rights are mentioned in the Constitution, then they become constitutional rights. When the workers' rights are mentioned, are covered by the Constitution, then they become the constitutional rights. You look into Article 39 of the Constitution of India, where you find equal right of men and women to adequate means of a livelihood, equal pay for equal work, and right to protect the health and strength of the workers. And if you look at Article 40, you find the right to work or the employment. Article 42, that deals with the just and human conditions of work. Article 43, the living wages for workers. Article 43A, participation of workers in the management. Some workers' rights are accorded the status of fundamental rights, like right to equality, Article 14, right to form the union or association, Article 19 clause 1, C, right against discrimination, Article 15, and right to life and personal liberty, Article 21. So here you find that, the workers' rights will be the human rights if they are covered by international human rights treaties or the conventions. In the absence of international human rights convention treaties, you cannot argue that workers' rights are the human rights. And in the absence of a statute, you cannot argue the workers' rights as statutory rights. In the absence of express provision in the Constitution, you cannot argue the workers' rights as the constitutional or the fundamental or the rights. Therefore, at the initial or in the beginning, I said, the issue of human rights of workers are debatable issues. It's very difficult to find a answer to this. It's very difficult to have unanimous the opinion about the nature of the human rights of the workers. So some rights are the human rights, some workers' rights are the statutory rights, some workers' rights are the constitutional rights, some workers' rights are fundamental rights. And coming to the rulings, as a student of law or as a teacher of a constitutional law, I will cite the case laws, and without citing the case laws, my discussion will be incomplete. So I have done a brief research about the human rights of the workers. In 1982, Ranadhir Singh versus Union of India. This is the leading case laws on the issue of equal pay for equal work. It was decided by the Supreme Court of the India. The question was whether equal pay for equal work should be viewed as fundamental right or mere directive principles as mentioned in Part 4 of the Constitution of India. The Supreme Court in this case observed that the principle of equal pay for equal work was not expressly provided for in the Constitution. Therefore, it was not accorded the status of a fundamental right. But by reading Article 14 and 16, along with the preamble and Article 39D of the Constitution of India, it makes it very clear that equal pay for equal work is a fundamental right. This is the first case wherein the Supreme Court transformed a directive principle into a fundamental right. Prior to this case, equal pay for equal work, right to demand equal pay for equal work was mere a directive principle of the state policy. Whereas the Supreme Court, they observed that the rule or the principle of equal pay for equal work is a fundamental right of the worker. So it is a landmark decision so far as human rights of workers are concerned. And as a result of this interpretation, the workers can demand equal pay for equal work for men, a fundamental right. Of course, as a student of law, you can make a comment over this approach or the interpretation because you do not find the rule of equal pay for equal work in Part 3 of the Constitution of India. You don't find this ruling, you don't find the equal pay for equal work as a fundamental right in Part 3. Yet, the court observed that taking into account Article 14 and 16 of the Constitution of India, the court observed that equal pay for equal work is a fundamental right. Therefore, it cannot be denied. It cannot be denied. In Dhirendra versus State of UP, which was decided in 1986, the question was whether casual workers who are employed on daily wages entitled for equal pay for equal work. So in Dhirendra versus the state of Uttar Pradesh, the question before the Supreme Court was the casual workers who are employed on daily wages basis, can they demand the equal pay for the equal work? The court observed that yes, it is a fundamental right. Therefore, the government cannot deny such benefits to the casual workers on the ground that they accepted the employment with less salary. Such denial would amount to violation of Article 14. So this is the second case in which the court has observed that casual workers who are employed on a daily wages basis, they can demand equal pay for equal work as a fundamental right. Therefore, it cannot be denied. So if equal pay for equal work is not followed by the employer, then it amounts to violation of the fundamental right of the worker. In another case, this is the case which concerns minimum wages. Whether the workers can demand minimum wages as a right guaranteed by the statute. We have a statute which provides for the minimum wages. Can the employer refuse to pay minimum wages to the workers? This question arose for the consideration of the Supreme Court in People's Union for Democratic Rights versus Union of India, or in other words, ACID project workers case. So here, the workers were employed by the contractors, but provided no facilities for them. No basic facilities like a shelter or food or even the drinking water. After the work, employees used to sleep on the street. Therefore, the NGO filed a writ petition before the Supreme Court arguing that non-compliance with the labor laws amounts to violation of right to live with human dignity, right to live with human dignity of the workers. In this case, Justice Bhagavati observed that non-implementation of right of workers by the private contractors and non-enforcement by the state authorities of the provisions for various labor laws violated the fundamental rights of workers to live with human dignity. So minimum wages cannot be denied. Minimum wages cannot be denied by the employer or even a private contractor. This decision has been heralded as a new legal revolution. It provided millions of workers protection, provided the millions of workers working in factories, fields, mines, and project sites with human dignity. So workers, it is the fundamental right of the workers to demand minimum wages, basic facilities like drinking water, shelter, crutches, medical aid, and safety in respective occupations covered by various welfare legislations. In another case, the question which attracted the attention of the Supreme Court was whether the temporary workers or the workers who are employed on daily wages can demand the regularization of their services, regularization of their other services. In Delhi Development Horticulture Employees Union, Delhi Development Horticulture Employees Union, Delhi versus Delhi administration, the petitioners who were employed on daily wages in Jawahar Rozgar Yojana filed a writ petition for their regularization in the development of the Department of Delhi administration. It was the contention of the
Sir, not audible, sir.
Sir, no audio, sir. Please see this.
Sir, not audible,
not
sir.
agree with the contents of the petitioner that right to demand regularization of a service is not a fundamental right, is not a fundamental right. The ruling of this court is good as it would help in preventing backdoor entry into government departments and public sector the undertaking. So here, merely because you work for a certain period of a time, work for longer the period of a time, it doesn't mean that it is your right to demand the regularization of a service as a fundamental the right. It is for the government or the employer to decide about the regularization of the services of temporary the employees. Now the question is whether provident fund contribution is a right of the worker or the employee. So this question was attracted the attention of the Supreme Court in Marathwada Gramina Bank Karamachari Sangatana versus management of a Gramina Bank. In this case, the court observed that failure on the part of the employer to pay provident fund the contribution violates the right of the worker, violate the right of the other workers. So workers are entitled for provident fund as a matter of right. It is the duty or the obligation of the employer to provide provident fund the contribution. So here the question is whether workers can demand right to work as a right to livelihood, right to work as a livelihood. In D.K. Yadav versus JMA Industries, the court observed that right to life enshrined in Article 21 includes right to livelihood. Therefore, termination of a service of a worker without giving him a reasonable opportunity of being heard is unjust, arbitrary, and illegal. In the instant case, the employee was terminated from the service without providing him a reasonable opportunity for being heard. Therefore, the court observed that termination of an employee from the services without complying with the due process of law, without complying with the opportunity for being heard, it violates right to livelihood guaranteed by Article 21 of the Constitution of India. So a workman cannot be removed from the service without providing him an opportunity of being heard, an opportunity of being heard, because fair hearing is a right guaranteed by Article 21 of the Constitution of India. Therefore, removal of an employee from the services without complying with the procedural law violates right guaranteed by Article 21 of the Constitution of India. In Kirloskar Brothers Limited versus ESI Corporation, the Supreme Court held that right to health is a fundamental right of the workman. The right is not only available against the state and its instrumentalities, but even private industries are to ensure the workman medical facilities. So in Kirloskar Brothers, the case, the court observed that it is the right of the workers to demand health care. This right is not only available against the state, even against private employer. So it is the obligation of the private employers, even the private employers should provide the medical facilities to the worker. In the state of the Punjab versus Mohan Singh, the court observed that the workers are entitled for medical reimbursement of expenses for treatment, including room rent charges. So in the subsequent case, the court observed that the medical reimbursement of expenses is the right of the workers. So the court has translate or transform the medical care as a fundamental right of the worker. Now the question is whether pension is a right, or is it a bounty payable at the mercy of the employer? So in Sukumar versus state of Kerala, this question was considered by the Supreme Court. The Supreme Court, which observed that pension is a succor for post-retirement period. It is not a bounty payable at will but a social welfare measure which helps the workman to maintain his dignity. The interpretation as a social welfare the measure. So in this case, the court observed that pension is a right of the workers. Therefore, it cannot be denied by the employer. Likewise, there are the number of case laws wherein the Supreme Court or the Indian Apex Court has given effect to the human rights of the workers. Now there are issues of labor rights or workers' rights, working hours. How long a worker may work? Is it for about the working hours? So it is a debatable issue. How long you can work? Can you work for 5 hours or 6 hours? Or is it a freedom of a contract between the employer and the employees? Or is it subject to any the statutory provisions of law? So it is a debatable issue. You can work 6 hours a day or 8 hours a day. It is for the government to stipulate working hours. And workplace condition.
Sir, no audio, sir.
Sir,
Sir, not audible.
sir, mute ಆಗಿದೆ ಸರ್ ನಿಮ್ದು. Sir,
Mute ಆಗಿದೆ
Sir,
ನೋಡಿ, sir.
not audible, sir.
Mute ಆಗಿದೆ ಅವ್ರದ್ದು.
sir, sir, ನಿಮ್ದು mute ಆಗಿದೆ ಸರ್, ಬೆಂಜಮಿನ್ ಸರ್.
Determining a living wage.
Sir, ನಿಮ್ದು mute ಆಗಿದೆ ನಿಮ್ದು.
Very. Hello?
Sir.
Hello?
Hello, sir.
Hello? Is it not audible?
Yes,
ಈಗ
sir.
audible, sir.
Is it not audible?
Audible, sir.
Did not audible, sir. Please, sir.
Yes. Okay. So ಕಾರ್ಮಿಕರ ಹಕ್ಕು ಎನ್ನುವುದು ಅದು ಕೆಲವೊಂದು ವಿವಾದವಾಗಿದೆ. ಯಾವ ರೀತಿಗೆ ವಿವಾದವಾಗಿದೆ ಅಂತ ಹೇಳಿ ವರ್ಕಿಂಗ್ ಅವರ್ಸ್ ಸಂಬಂಧಪಟ್ಟಾಗೆ.
Sir, some of the people from outside Karnataka, sir.
Okay, it's all right.
Thank you for representing me.
Yes. Okay, it is a debatable issue. The issue of working hours is a debatable issue. How long you can work? It is decided by the state or the government. The 5 hours, 6 hours, 7 hours, or 8 hours, it is left to the government to decide. And similarly, what constitutes living wage? It's very difficult to define. Very difficult to identify or to determine the living wage. And if you look at the globalization, you find the dilution of workers' rights. Dilution of workers' rights. In order to attract investment from the overseas, the government has the compromised over the issue of the workers' rights. Again, it is open for debate, the discussion, the impact of globalization upon the workers of the rights. And migrant workers' rights, it's very difficult in the present scenario. It's very difficult to ensure the protection for migrant workers. But you can discuss how these issues could be resolved. So this is my the brief the lecture on the human rights of workers. I open the session for interaction.
Okay, sir.
So if you have any question or any doubt, or if you want to make any comment, so you are free to express.
Sir, I am Dr. Mangaleshwari from Dharmapuri, Tamil Nadu, sir.
Okay.
While addressing, you said that regularization occurs temporary
Pardon me?
employees, right?
Hello?
Madam, your voice is not audible.
Regularization service. Hello? Am I audible?
No, I am not able to hear you. No, not audible. I am not able to hear you.
Sir, while addressing, you said, can you hear, sir?
Okay. Hello?
The regularization of service of temporary employee is not a right, you said, sir.
Yes.
Sir,
Yes.
there are temporary employees working with the equal
Yes.
qualifications, sir, but they are not equally paid on par with regular employees.
No, so far as equal pay for equal work is concerned, it is a right. Even
But
the
it is
employees
not
who are employed. So far as equal pay for equal work is concerned, it is a fundamental right. The regular employees or the employees who are working on a temporary basis, they are entitled for equal remuneration of the regular employees. The employer cannot discriminate between the regular employees and the temporary employees so far as remuneration is concerned.
But in government colleges, sir,
Yes.
temporary employees in the name of guest lecturers, they are appointed as guest lecturers, sir.
No,
They are
equal pay for, yes.
per month.
Yes, I can understand. Equal pay for equal work doesn't mean that all employees are entitled for uniform pay scale.
But they are
It
equal.
depends on, no, it depends on the nature of the employment, the nature of the recruitment, responsibilities, and performance of the employees. So taking into account these factors, the employer may pay different pay scale for the employees. They may work 3 hours a day. They may take the class 3 hours a day, but it doesn't mean that they're entitled for equal pay or entitled for the pay scale on par with regular employees. You have to take into the consideration the nature of their employment, whether they are the permanent employees, on the nature of recruitment, how the employees are appointed, whether employees are appointed through direct the recruitment process or by or any other means, and their responsibilities, the qualifications, the competence, everything should be taken into consideration. Then only you can demand the equal pay for equal work.
Nature of appointment alone, they are being deferred.
Pardon me?
But so by virtue of nature of appointment,
Yeah.
we are enjoying about 6-fold of payment, no, sir.
Yes, that is true. That is true. Yes. This is you are talking about a teacher's pay scale. This is the issue which concerns the workers.
Sir,
Teachers are not workers.
Sir, this is that Lavish from government language school. We have to see the definition of the, employer under the Equal Remuneration Acts. Then we can apply this Equal Remuneration Act to them. We have to see that whether this teacher will come under definition or not, we have to see. Then only we can tell that whether they will be applicable or not. Hello?
Okay, madam. Thank you so much.
Thank you. Mute ಆಗಿದೆ sir.
Hello.
Thank you, sir. Mute ಆಗಿದೆ.
Hello.
Sir. Hello. Can you hear me, sir?
Yes.
Sir.
Yeah. Now I can hear you.
Sir, what I'm telling to the madam, so the Equal Remuneration Act, we have to see the definition of the employer, Equal Remuneration Act. Then only we can apply about that. Whether the teacher has will come under the definition or not, we have to see. Then we can apply. Otherwise, we can't apply.
Teachers are not workmen.
That's what I'm telling to her, sir.
Yes,
If
yes.
the madam
Teachers
is
are not
asking, no.
workmen. Yes.
Yes, yes. So
Okay,
it's whether
sir.
it's a workman or not, whether they will come under the definition
Yes,
or
yes.
not, we have to see first.
Yeah. No,
Sir,
it's very clear. It's a well-established principles of law that teachers are not the laborers.
it's
So
not
teachers cannot
considered.
invoke.
The simple thing
Teachers
is,
cannot invoke.
yes.
Hello?
Sir, sir, can you audible for me, sir?
Yes.
Can you
Yeah,
hear me?
yeah, no, yeah.
Sir,
Yes, yes, yes.
you mentioned with regard to the globalization, that is the dilution of workers' right through the globalization.
Yeah.
How it is possible, sir? What is
No,
the,
but
can you
you know,
explain, sir?
See, as a result of COVID-19,
Mm.
most of the state governments have suspended the operation of labor laws. The main reason is to attract investment from overseas companies. If you stick on to the labor laws principles, in India, there are 40 labor laws, 40 labor laws.
More than that, sir. More than
Yes,
that.
yes, this is central legislations. Central legislations. If you stick on to the labor law, it's very difficult to attract the investment from the overseas. Therefore, the government has relaxed the labor laws. It's unfortunate. In order to attract the investment from the overseas, there's no need of compromising or diluting of labor laws, but the government has the thought that it is the necessary to attract the investment. Globalization has adverse impact upon rights of workers. You cannot demand the fair wages. The employer has right to hire and fire. So
Sir,
if you
then what is the Payment of Wages Act, Minimum Wages Act, what for it is there? If they
Yes,
mention
it
like
is.
that, if the government
Yes,
is thinking about only the globalization and investing, inviting the other,
Yes,
foreign
yes.
companies, then what is the need
Yeah.
of these two legislations? What did these two legislation will do?
Yes, yes, I can understand. But the aggrieved should challenge the policy of the government, action of the government before the court of law, you know. If you are aggrieved by the action or the decision of the government, and if
Sir,
you think
aggrieved is different when the legislation, central government is enacted legislation, they have
Yeah.
to give respect to those legislations. If the government
Yes.
itself is going, means it's
Yes.
definitely violation, sir, of the fundamental
yes,
rights.
yes, yes, if there is failure on the part of the government to comply with the labor laws, the remedy available at the court of law, you know.
So
Should
when this
appoint the court
statement
of
is
law.
passed, when this statement is passed by the government, sir, can you give the
Pardon
reference?
me?
please? When the government is passed this, what you can say that suspension of the labor laws, can you give the reference for that, sir, please?
No, it might be in April or May.
In which
April or
paper,
May
sir?
of
They're published in the paper?
Yeah, it was reported in the newspapers, you know. And many
April?
states have suspended.
Excuse me, sir.
Particular, state of Madhya Pradesh. State
Hello?
of Madhya Pradesh. State
Sir.
of Uttar Pradesh. Yes.
Hello, sir. While government is establishing a special economic zones where this labor law is not applicable, sir. Special economic
yes,
zones.
yeah.
So that is the thing is that, sir. And I think in
Yes,
2005, this all these special economic zones are established where they are barred from the applying the labor laws, sir.
It's an exception.
Yes, sir.
Yes, it's an exception. Yes. So far as economic zone is concerned, the labor laws are not applicable.
Yes,
The
sir.
government has excluded the special economic zone from the purview of the labor laws. This is with a view to
Labor law.
attract investment.
Yes, sir.
Yes.
How it will
No,
be
the
possible,
government
sir?
has adopted. Pardon me?
How it is possible, sir?
Hello?
See, economical growth of the government, the country is important. At the same time, they have to protect the human rights. And what for the UDHR and Covenant on Economic, Social, Cultural Rights, all these are adopted by the government and become a member and passes so many legislations under for the labor, sir.
Yes, it is the responsibility of the
Foreign
government to respect,
investment
protect, and fulfill the
policy.
obligations of the human rights law. It is the responsibility. So in the event of a failure on the part of the government to respect the human rights obligation, then you have to approach the court of law seeking remedies.
So any Supreme Court decisions are there, sir? Because Supreme Court has brought the directive principles of state policy into fundamental rights, and they are fighting for the rights of the workers. Then why this Supreme Court has kept quiet with regard to these things, sir?
No, that case was decided. That case was decided during 1980s when the judiciary adopted pro-employees approach. During 1970s and 80s.
No, you told with regard to pandemic period. You don't know, no, sir. During the pandemic period, not the 80s case, sir.
Yeah. No, you repeat your question.
Sir, you told that here the labor laws are suspended to attract the investment of the other countries, and moreover with regard to the economical zone to develop the economic of the country. In those circumstances, why the Supreme Court, if they're suspending the rights, means Supreme Court is keeping quiet, and if they are doing any initiation to protect the rights of these workers, sir?
Yes, during the COVID-19 period, you had seen the pathetic condition of migrant workers.
But after that,
many lost their
after that they have given a
job
package,
and
sir.
employments.
So that
Many lost
so
their
many
lives.
packages.
No,
Yes,
that
yes.
is after, yes, it was too
Yes.
late. So
But
after,
we don't know whether it will reach to them or not.
no, this is even today, so far as migrant workers' rights are concerned, judiciary has failed to safeguard their rights.
Yes.
Judiciary did not consider the issue of migrant workers as important matters for hearing.
Yes.
When it was criticized, when the judiciary was criticized by the scholars, then the judiciary took up the issue of migrant workers. By that time, 4 to 5 months they passed.
Thank you, sir.
Yes, okay. Any other question? Any comment you could supplement? You could supplement your views. You need not agree with me. I
Yes.
quoted a number. I quoted number of case laws as I am as a student of law. I discussed a number of case laws. I do not know how far you are able to digest it.
Sir, even
So
I'm also law student only, sir. My specialization in labor laws. So
Okay,
I'm
so
so much worried about this.
Yes, good.
Suspension of the
Then you
rights, everything.
then you know the condition of workers
Yes, yes, sir.
and the approach of the judiciary
Yes, sir.
during the pandemic, the COVID-19 and the pandemic.
Yes, 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 sir. This is very
Yes, it
pathetic
is really-
condition, but
is
they have
really
given
unfortunate.
packages, but we don't know whether it is reached to them or not.
No, the government has announced packages, as you said. We do not know how many the employees or migrant workers who benefited from it. We do not know.
Yes.
Even the government has not maintained statistics about migrant workers.
Yes, they're not maintain the statistics.
Yeah, the Minister of the Labor and Employment admitted on the floor of the Parliament that there was no statistics about migrant workers. This is the situation.
We
you know,
did
this
try
is
for
the
that, sir. How can
reality.
we tell like that?
Yes, the government is not, they consider the issue of labor as the important issues.
Yes, this is.
For
correct.
government,
But
investment is important.
but
Investment.
during the pandemic period, so the most of the sufferers are the migrant workers only.
Yes, yeah. Yes, it is. That's why I said
Yes,
it is a debatable issue. How far the rights of the migrant workers are protected, it is a debatable issue.
Yes.
Sir, one more question, sir.
Yes, please.
Sundar Murthy, Anur College.
Okay.
ಈಗ
Okay, ಹೇಳಿ, ಸುಂದರಮೂರ್ತಿ ಹೇಳಿ.
ವರ್ಕರ್ಸ್ ಗಳಿಗೆ ಸರ್ಕಾರದಿಂದ ಇಷ್ಟು ಅಮೌಂಟ್ ನಿಗದಿ ಮಾಡಕ್ಕಾಗಲ್ವಾ? ಯಾವ್ಯಾವ ಪೋಸ್ಟ್ ಗಳಿಗೆ ಎಷ್ಟೆಷ್ಟು ಆಗುತ್ತೆ ಅಂದ್ಬಿಟ್ಟು ಫಿಕ್ಸ್ ಮಾಡಕ್ ಆಗಲ್ವಾ? ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಈಗ ನಮ್ಮ ಕೊಲಿಜಿಯೇಟ್ ಅಲ್ಲಿ ಗೆಸ್ಟ್ ಲೆಕ್ಚರ್ಸ್ ಗಳಿಗೆ ಒಂದು ರೈಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ, ಅದೇ ರೀತಿ ಅಲ್ಲಿ ವರ್ಕರ್ಸ್ ಗಳಿಗೆ ಮಾಡಕ್ ಆಗಲ್ವಾ ಅಂತ.
ಮಿನಿಮಮ್ ವೇಜಸ್ ಆಕ್ಟ್ ಇದೆ.
Sir, minimum wages act is there, sir.
Yeah, it is there. Minimum wages act is there.
ಬಟ್ ಅದಿದ್ರೆ
ಇದೆ
ಸುಮಾರು
ಸ್ಟ್ಯಾಟ್ಯೂಟ್ ಇದೆ ನಿಮಗೆ. ಸುಂದರ್ ಮೂರ್ತಿ ಅವರೇ,
ಹೇಳಿ ಹೇಳಿ.
ಮಿನಿಮಮ್ ವೇಜಸ್
ಹೌದು
15,600 rupees is fixed as a minimum wages. 15,600 ರೂಪಾಯಿನ ಮಿನಿಮಮ್ ವೇಜಸ್ ಅಂತ ಹೇಳಿದೆ.
ಹೌದು ಹೌದು
ಮಿನಿಮಮ್ ವೇಜಸ್ ಅದು
ಬಟ್
ಕೊಡ್ಲೇಬೇಕು.
ಬಟ್ ಅದು ಕೆಲವು ಕಂಪ್ನಿಗಳು ತಗೊಳಲ್ವಲ್ಲ, ಅದಕ್ಕೆ ಏನ್ ಪನಿಷ್ಮೆಂಟ್ ಇದೆ?
ಲೇಬರ್ ಅಥಾರಿಟೀಸ್ ಗಳನ್ನ ಅಪ್ರೋಚ್ ಮಾಡಬೇಕು. ಲೇಬರ್ ಕಮಿಷನರ್ಸ್ ಇದ್ದಾರೆ, ಲೇಬರ್ ಕಮಿಷನರ್ಸ್ ಹತ್ರ ಇಶ್ಯೂನ ತಗೊಂಡು ಹೋಗ್ಬೇಕು. ಅಲ್ಲಿ ಅವ್ರು ಹೇಳ್ಬೇಕು, ದಿ ಎಂಪ್ಲಾಯರ್ ಹ್ಯಾಸ್ ಫೇಲ್ಡ್ ಟು ಪೇ ದ ಮಿನಿಮಮ್ ವೇಜಸ್ ಹ್ಯಾಸ್ ರಿಕ್ವೈರ್ಡ್ ಬೈ ದಿ ಸ್ಟ್ಯಾಟ್ಯೂಟ್. ಸೊ ಇಟ್ ಈಸ್ ಎ ಫೇಲ್ಯೂರ್ ಆನ್ ದಿ ಪಾರ್ಟ್ ಆಫ್ ದಿ ಎಂಪ್ಲಾಯರ್ ಟು ಕಂಪ್ಲೈ ವಿತ್ ದಿ ಸ್ಟ್ಯಾಟ್ಯೂಟರಿ ಆಬ್ಲಿಗೇಷನ್ಸ್ ಅಂತ ಹೇಳಿದಾಗ, ಆಗ ದಟ್ ಇಶ್ಯೂ ವಿಲ್ ಬಿ ಟೇಕನ್ ಅಪ್ ಬೈ ದಿ ಅಥಾರಿಟೀಸ್ ಕನ್ಸರ್ನ್ಡ್. ನಾವು ಯಾರ ಹತ್ರನೂ ಅದು ಆ ಇಶ್ಯೂನ ತಗೊಂಡು ಹೋಗದೆ ಇದ್ರೆ ಅಥಾರಿಟೀಸ್ಗಳು ತಾವು ಬಂದ್ಬಿಟ್ಟು ಮಿನಿಮಮ್ ವೇಜಸ್ ಕೊಡಲ್ಲ ಅವರು.
Sir, one thing I want to add this point, sir.
Okay.
See, the persons who are appointed and the inspectors and the persons level officers,
Yeah.
sometimes they won't visit that spot also, sir. Because
Yes,
I
yes.
did my small dissertation under the quarry workers. The
Okay.
quarry workers, they doesn't know about any inspector who has not visited any time. Moreover, ಈಗ
Yes,
ಇನ್ನೂ
yes,
ಏನಾಗ್ತಾ ಇದೆ ಅಂತಂದ್ರೆ, ಈಗ ಗಾರ್ಮೆಂಟ್ ಫ್ಯಾಕ್ಟರೀಸ್ ಅವೆಲ್ಲ ಔಟ್ಸೈಡ್ ಸ್ಕೌಟ್ಸ್ ಆಫ್ ಬ್ಯಾಂಗ್ಳೂರಲ್ಲಿ ಇರೋದೆಲ್ಲಾನು ಇನ್ಸ್ಪೆಕ್ಟರ್ ಏನ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ, ಏನೋ ಹೋಟೆಲ್ ಅಲ್ಲಿ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಮೀಟ್ ಮಾಡ್ಕೊಂಡು ಎಲ್ಲ ಬರ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದಾರೆ ಸರ್. ದೇ ಆರ್ ನಾಟ್ ವಿಸಿಟಿಂಗ್ ಪ್ರಾಪರ್ಲಿ ಟು ದ ಸ್ಪಾಟ್ ಆಲ್ಸೋ. ದಟ್ ಈಸ್ ಆಲ್ಸೋ ಒನ್ ಥಿಂಗ್. Moreover, minimum wages ಅನ್ನೋದು ಗವರ್ಮೆಂಟ್ every year they are basing on the cost of living, they are changing, sir. Minimum wages change ಆಗ್ತಾ ಇದೆ. But implementation is not there. It is failure for the implementation. So ಯಾಕಂದ್ರೆ ಪಾಪ ವರ್ಕರ್ಸ್ ಕೇಳುವಾಗ ಈ ಸ್ಟ್ರೈಕ್ಸ್ ಅದು ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಅವರಿಗೆ ಮತ್ತೆ ಅದೂ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ಬಿಡುತ್ತೆ. Moreover, illegal strike again they had to go for Industrial Dispute Act. ಅದರಿಂದಾನು ಅದು ಸ್ವಲ್ಪ ಹಿಂದಕ್ಕೆ ಹೋಗಿ, it is not justifiable for the workers. ಪಾಪ ಇನ್ನು ಡೊಮೆಸ್ಟಿಕ್ ವರ್ಕ್, ಡೊಮೆಸ್ಟಿಕ್ ವರ್ಕರ್ಸ್ ನೋಡ್ರಿ, ಅವರು ಇಷ್ಟು 100 rupees for ಅವರ್ ಅಂತ ಹೇಳ್ತೀವಿ.
ನಮ್ಮ ಪ್ರಾಬ್ಲಮ್ ಇರೋದೇ ಇಂಪ್ಲಿಮೆಂಟೇಷನ್ ಅಲ್ಲಿ.
ಇಂಪ್ಲಿಮೆಂಟೇಷನ್ ಅಷ್ಟೇ. ಲಾ ಇಸ್ ವೆರಿ ನೈಸ್, ಬಟ್
ನಮಗೆ ಲಾಸ್ ಬಹಳ ಚೆನ್ನಾಗಿದೆ. ವಿ ಹ್ಯಾವ್ ಎಕ್ಸಲೆಂಟ್ ಲಾಸ್. ಯಾವ ಕಂಟ್ರಿ
ಲಾ ಅವ್ರಿಗೆ ಈಸಿ ಸರ್, ಲಾ ಅವ್ರಿಗೆ ಈಸಿ. ಎಲ್ಲಿಗೋದ್ರು ಲಾ ಹೇಳ್ಬಿಟ್ಟು ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಇಂಪ್ಲಿಮೆಂಟೇಷನ್ ಪ್ರಾಬ್ಲಮ್ ಅಂದ್ರೆ ಹೇಳಿದ್ರೆ ಹೋಯ್ತು ಅಷ್ಟೇ.
ಹೌದು.
ಸರ್ ನಮಸ್ತೆ, ಶೈಲೇಶ್ ಕುಮಾರ್ ಸರ್ ಫ್ರಮ್ ಹನೂರ್ ಕಾಲೇಜ್.
ಹೇಳಿ. ಎಸ್
ಸರ್, ಈಗ ನೀವ್ ಹೇಳಿದ್ರಿ ಕನಿಷ್ಠ ವೇತನ ನಾವು ಡಿಮಾಂಡ್ ಮಾಡಿದ್ದೆ ಆದ್ರೆ ಅವ್ರನ್ನ ಟರ್ಮಿನೇಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಬ್ಲಾಕ್ ಮೇಲ್ ಮಾಡ್ತಾರಲ್ಲ.
ಟರ್ಮಿನೇಟ್ ಮಾಡಲಿಕ್ಕೂ ಆಗಲ್ಲ. ಟರ್ಮಿನೇಟ್ ಮಾಡೋದಕ್ಕೂ ಸಹ ಒಂದು ಡ್ಯೂ ಪ್ರೊಸೆಸ್ ಫಾಲೋ ಮಾಡಲೇಬೇಕು. ಈ ವರ್ಕರ್ಸ್ ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅನ್ನೋದಾದ್ರೆ, ಅವ್ರಿಗೊಂದು ಫಿಯರ್ ಇದೆ. ನಾವು ಏನಾದ್ರು ಮಿನಿಮಮ್ ವೇಜಸ್ ಡಿಮಾಂಡ್ ಮಾಡ್ಬಿಟ್ರೆ ನಮ್ಮನ್ನ ಸರ್ವಿಸ್ ಇಂದನೇ ತೆಗೆದು ಹಾಕಬಹುದು ಅಂತ ಒಂದು ಡಿಮಾಂಡ್ ಇದೆ. ಈ ವರ್ಕರ್ಸ್ ರೈಟ್ಸ್ ಅನ್ನ ಯಾವಾಗಲೂ ನಾವು ಇಂಡಿವಿಜುವಲ್ ರೈಟ್ ಆಗಿ ಕನ್ಸಿಡರ್ ಮಾಡಬಾರ್ದು, ಕಲೆಕ್ಟಿವ್ ರೈಟ್ ಆಗಿ ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕು. ಇಂಡಿವಿಜುವಲ್ ರೈಟ್ ಆದ್ರೆ ಎಸ್, ಯು ಹ್ಯಾವ್ ಅ ಫಿಯರ್ ಅಂಡ್ ಇಫ್ ಯು ಡಿಮಾಂಡ್ ದ ಮಿನಿಮಮ್ ವೇಜಸ್ ಯು ಮೇ ಬಿ ಟರ್ಮಿನೇಟೆಡ್ ಫ್ರಮ್ ಸರ್ವಿಸ್. ಆದ್ರೆ ಈ ಸೋಪರಸ್ ಲೇಬರ್ ರೈಟ್ಸ್ ನ ಸಂಬಂಧಪಟ್ಟಾಗೆ ಕಲೆಕ್ಟಿವ್ ಆಗಿ ಫೈಟ್ ಮಾಡಬೇಕು. ಕಲೆಕ್ಟಿವ್ ಆಗಿ ಫೈಟ್ ಮಾಡಿದಾಗ ಯು ವಿಲ್ ಸಕ್ಸೀಡ್. If you take up the labor right issue as individual issue, individual dispute, then it's very difficult. You cannot fight against a mighty employer. Employer is always so strong. You being an employee or the employee, you cannot fight against the employer. Adakagi, you have to fight collectively, not individually. Collective agadaga, nimma prayatnadalli ನೀವು ಸಕ್ಸಸ್ ಆಗ್ತೀರಿ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ವರ್ಕರ್ಸ್ ರೈಟ್ಸ್ ಹೇಳೋದೇ ಹಾಗೆ, ಕಲೆಕ್ಟಿವ್ ರೈಟ್ಸ್ ನಾಟ್ ಇಂಡಿವಿಜುವಲ್ ರೈಟ್ಸ್. ಬಟ್ ಅನ್ಫಾರ್ಚುನೇಟ್ಲಿ ನಾವ್ ಏನ್ ಮಾಡ್ತೀವಿ ಅಂದ್ರೆ, ನಾವೇ ತಗೊಂಡೋಗ್ಲಿಕ್ಕೆ ಟ್ರೈ ಮಾಡ್ತೀವಿ. ನನ್ನ ಒಬ್ಬನಿಗೆ ಸಂಬಂಧಪಟ್ಟದಂತ ಫೈಟ್ ಮಾಡ್ತೀವಿ, ಬೇರೆಯವ್ರು ಯಾರು ಬರೋದೇ ಇಲ್ಲ. ಟ್ರೇಡ್ ಯೂನಿಯನ್ಸ್ ಇದೆ, ಟ್ರೇಡ್ ಯೂನಿಯನ್ಸ್ ಸಹ ಡೈಲ್ಯೂಟ್ ಆಗ್ಬಿಟ್ಟಿದೆ, ಅವರು ಕಾಂಪ್ರಮೈಸ್ ಆಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅವರು ಒಂದು ಪೊಲಿಟಿಕಲ್ ಐಡಿಯಾಲಜಿ ಮೇಲೆ ಟ್ರೇಡ್ ಯೂನಿಯನ್ಸ್ ಗಳು ನಿಂತಿವೆ. ಯಾರು ಟ್ರೇಡ್ ಯೂನಿಯನ್ ಕಾಸ್ ಬಗ್ಗೆ ಫೈಟ್ ಮಾಡೋರು ಇಲ್ವೇ ಇಲ್ಲ ಇವತ್ತು.
Sir, people are selfish, sir. Trade union leaders are become selfish. ಅವನ ಪಕ್ಕದಲ್ಲಿ ಕೊಟ್ಟು ಬಿಡ್ತೀವಿ ಆಯ್ತು.
So once you become a trade union leader, then you will become selfish.
Yes. ಹೌದು ಸರ್. ಟ್ರೇಡ್ ಯೂನಿಯನ್ ಲೀಡರ್ಸ್ ಮಾಡ್ತಾ ಇರೋದು ಆನ್ ಬಿಹಾಫ್ ಆಫ್ ವರ್ಕರ್ಸ್, ದೇ ಆರ್ ನಾಟ್ ವರ್ಕಿಂಗ್. They are seeing their own selfishness.
No, the unfortunate thing is we have trade unions based on political ideologies.
Yes.
This is really unfortunate.
Yes, sir. See, in the beginning, it is only for the workers only. Now it is diluted totally.
Yes.
That motive is gone, and that goal object is not there in the trade unions. Moreover, multi-trade unions, sir. Mushrooms, like that, mushrooms, they are in the, they are getting this trade union because the minimum membership is very less in the registration of trade union. So they are going for that one.
Yes, madam, yes. Now that is the reality. But
Yes, sir.
as a teacher of law, we cannot talk about reality, you know. You will speak about.
No, sir, we had to. But one more thing, if they can amend the trade union, they can enhance that membership, sir. Then only this mushrooms of trade union will not be come up.
Yes, madam, I do agree with your the point of view.
Thank you, sir.
Okay. I think time is run up.
Yes, sir. Any questions? Sir, this is Dr. Mamta. So it's my privilege to propose a vote of thanks to our guide, Dr. M.S. Suresh Benjamin, sir. Sir has given an excellent coverage on right to workers and along with the case laws. On behalf of HRDC and all the participants, I extend warm thanks to you, sir. Thank you, sir.
Okay. Thank you, Mamata. Thank you very much.
Thank you,
Thank you, sir. Thank you very much.
Thank you very much, sir.
Humiliation.
Thanks a lot, sir.
All the participants, sir. Thank you very much.
Okay, thank you.
Thank you, sir. Thank you very much, sir.
Thank you, sir.
Okay.